you're likely going to have an attorney appointed for your children. You're putting your children squarely in the middle of your dispute, and that extra overnight down the road is in no way comparable to the negativity that comes from putting children through the litigation. And again, sometimes it is necessary because the protection is needed or there's some reason why you have to be in court. But if it's not necessary, it's better to try and find a way in which you make, when your co-parent together can make that decision. Not to mention, you mentioned spending every last dollar. I mean, litigation is as expensive as it gets. I often say to clients, if this is what you want to do, that's great, but that money could be better spent on your children 10 years down the road. It'd be better if that's in their 529 account for the children than it is being spent on legal fees, out to attorney for the children, to the attorneys, to motion papers, to all of these things in which money is usually better spent on your kids in that manner.
I'm Rachel Green, divorce mediator and collaborative attorney. Join me as I chat about everything from smoothly navigating your way through divorce to prenups, all the while keeping the kids in mind.
I'm Rachel Green. Welcome to Keep the Kids in Mind. Today, I'm really pleased to have a conversation with Ian Steinberg. He's a partner with Berkman Bottger Newman Schein, which focuses on the mediation, negotiation, litigation, and settlement of complex high net worth matrimonial and family law cases. It's one of the premier matrimonial boutique firms in New York City. He's trained in mediation and collaborative law and specializes in prenuptial and postnuptial agreements. Always sensitive to his clients' emotional needs, Ian helps them obtain results to ensure a stable and successful future. Ian, welcome to Keep the Kids in Mind.
Thank you so much for having me, Rachel.
Just to start, why don't you tell us what has drawn you to this work? What has led you to want to talk to families who are in conflict?
Yeah, so it's interesting. I started my legal career as a real estate attorney, and I did that for about 5 years. And to me, I was missing a personal connection, missing the change of pace, every day being different and every hour within every day being different. And I've always been drawn to trying to help people going through difficult times, and especially trying to help children. And I didn't feel like I was getting that in the real estate world. I mean, to a degree, we were representing big pieces of steel in New York City, which is very different than my clients right now. And I was just very drawn to being able to really have an impact on people's lives and help them going through a difficult time with an eye on the children always. And that's really what drew me to practicing matrimonial and family law.
Yeah, I think that children is part of what drew me to this work too, which is why my podcast is called Keep the Kids in Mind. I mean, I find that, the situation that children find themselves in when they didn't ask for the divorce and they have to do so much adjustments, that really moves me. And it has definitely been kind of a thread through my work and, trying to help people getting through the transitional part, which is so stressful.
And it's interesting what you said about it not being their choice. And it wasn't their choice. This is a situation that now they're thrust into, and their parents are so emotional, understandably, as they're going through this process. But sometimes that leads parents to forget about the kids, and not that they're forgetting about them. Obviously, they're a big part, but forgetting the impact that what they're doing and what they're going through has on their children. And going through an intense custody battle is maybe what the parents think is best at that time, because they really are trying to do what's best for their kids, and they think the kids being with them is what's best. But they kind of forget how difficult it is for the kids to be involved in this process, and they are involved in it. And that's why I think when parents can take a step back and realize, we need to really put our kids first, that's a good sign for their future and can help set them and their kids up for a better future.
I really like what you wrote in your bio, that you're trying to think about the longer term, because people who are embroiled in conflict are so focused on the issues that they're fighting about. And, it helps to remind clients that they're going to feel differently in 5 months, they're going to feel differently in 5 years, and try to take the long view. I had somebody who likes to remind people, like, what is your 16-year-old going to say to you when he comes to you and says, why did you do that to my dad? Or why did you do that to my mom when I was 5? And, it's a very startling thing to think about for many clients.
But I think that's a great way of looking at it, because what you're doing now, and like you said, Rachel, it's so true that people are so focused and emotional about what's going on right now. And if you don't take that long-term look, you don't think, how is this going to impact me and especially my children? To your point, 10 years down the road, you're going to make decisions now likely that are not realizing what the long-term impact of it is. But it's understandable, right? Like, you're going through such an emotional time, and you're doing things that you think are best, but sometimes your judgment is clouded just because of how emotional it is. And taking that step back, and I think that's a great thing, and I may have to steal that from you and your client. I'll give you copyrights. But I think that when you can look that far down the road and realize, both from a custody and from a financial standpoint too, and kind of take a look at what is this going to do 10 years down the road. Hopefully that means you'll make better decisions now and healthier decisions, at least I would hope.
And your practice differs from mine in that I don't do any litigation, but you do litigation and mediation and collaborative divorce. And I'm wondering how you've seen the different processes impact your clients.
So I think it takes, and I'm sure you feel similarly, I think it takes a certain couple and a certain family to be able to engage in the mediation or the collaborative process. It's very easy to litigate, right? Because in terms of to make that process choice, it's I want to go scorched earth, so let me just file every motion and do everything that I can down that road. I think it's a hard decision for people to make, to say, let me engage in a more nicer isn't the right word, but a better process.
My perception is that people have a fantasy that if they go to litigation, their attorney says, it's okay, I'll take care of this now. So it's like they're giving this huge morass of conflict and pain, and they're giving it to their attorney and saying, oh, he's going to take care of it, and I don't have to be involved. And I think mediation and collaborative divorce ask the clients right from the beginning to be more involved. It doesn't work that way in litigation either.
I mean, that's a really good way of putting it. I've never really thought of it that way, but it's right. I think when you're engaged in the mediation process or the collaborative process, the mediator's facilitating the conversation, but it's the parties who are really doing the work, as opposed to when you're litigating, you're taking a step back as the party and saying, my attorney is taking the reins and sort of charting the course of the litigation, which, look, sometimes it has to be done. There's sometimes where there are certain issues, there are certain things that they need court intervention, they need help. But when you can avoid it, you're right, you have the parties, the couple, who are really charting the course as opposed to a judge or to lawyers or things like that.
And I think that I've also seen situations where people have said things like, I can't let go of this issue because I'm fighting for my son. And I want him to know that I fought with every ounce, every dollar that I have in me. And if I settle, if I give up on him spending Tuesday overnights at my house, he's going to think I didn't love him enough.
And what ultimately will happen in that situation is that if you're a parent and you're a good parent and you care about your child, they're going to know that. It's going to come through.
Right. Raising children is a marathon, not a sprint.
And I'm at the very beginning of the process.
That's right. There you go.
And so I certainly understand that there's a long way to go with that. And I think that's right. But when you really think about what you're doing to your kids when you're litigating, look, now you're going to have potentially a judge saying when you're going to be with your kids. You're likely going to have an attorney appointed for your children. You're putting your children squarely in the middle of your dispute, and that extra overnight down the road is in no way comparable to the negativity that comes from putting children through the litigation. And again, sometimes it is necessary because the protection is needed or there's some reason why you have to be in court. But if it's not necessary, it's better to try and find a way in which you and your co-parent together can make that decision. Not to mention, you mentioned spending every last dollar. I mean, litigation is as expensive as it gets. I often say to clients, if this is what you want to do, that's great, but that money could be better spent on your children 10 years down the road. It'd be better if that's in their 529 account for the children than it is being spent on legal fees, out to attorney for the children, to the attorneys, to motion papers, to all of these things in which money is usually better spent on your kids in that manner.
But then it'll go into your son's 529 account.
That's true. And that's what we say in this office a lot. The joke is, whose 529 account would you rather fund, yours or mine? Because sometimes that helps people recognize, look what you're spending this money on what? On one dinner, on one, something really small in the scheme of things versus the opportunity to go to college or to, help with that extracurricular activity or something else where when you put it in those terms, hopefully that's something that allows them, it hits home a little bit more.
And do you have a sense of, currently like what is kind of the average maybe of what a litigation process costs? There must be a wide range because most people don't end up going to trial, right?
Yeah, I mean, trials are few and far between, I think, but it's the lead up to trial that sometimes is even more expensive than the trial itself.
Oh, really?
Well, you're dealing with, if you're getting to that point, you have probably lots of motion papers for all different issues related to both the finances, to the custody.
And motion papers are like making an argument to the judge?
It's making an argument to the judge in paper where there's an attorney affirmation which talks about the law. It's a party affirmation which talks about the facts and the circumstances. And then there's opposition on the other side. Sometimes there's a cross motion where they're asking for certain relief, all so that the judge can say, here's when you're going to see your kids. But then you're paying an attorney for the child. Then there's the child support element to it. And then there's discovery and there's conferences with the court and maybe some settlement conferences. And then a preparation for trial, which usually the preparation is more than the actual trial itself may cost. And how many years also does it take? So now let's forget the financial cost.
How many years does it take?
It could take 3, 4, 5 years to actually get to the point of a trial, at least in the city, at least in Manhattan, Brooklyn. Westchester can be a different animal. They usually push the cases a little bit faster there. Long Island is similar in terms of pushing the cases a little bit faster. But even so, I mean, the financial cost, but the emotional cost too. And again, like sometimes things need to be done in that manner, and sometimes a couple just can't get along where the mediation just isn't the right process or collaborative isn't the right process. But where it can be done, it's a really good place to be.
I had a client who, when I was having a mediation, we had several sessions, maybe 5 or 6 mediation sessions, and we're stuck on some issues. And he said, "This isn't working for me. I'm gonna go to court Monday. Do you think the judge will give me a decision that day?"
But it's a common misconception that because you're in court, a judge is going to rule on your issues quickly. And that couldn't be further from the truth. I mean, the first thing that people have to do is either file a motion asking for relief or file for a preliminary conference with the court, which in some cases can be within a week or two, and in some cases could be within a month or two. And that's just a preliminary conference. I mean, the delay that can take place in the court system is massive, and you don't get the decisions that you want right away. It takes a lot of time, money, and emotional expense to get to that point too.
Yeah, I had a case with a couple that have one son. They were in court, and their attorneys, they were in family court because they weren't married, and they were arguing over child support and custody. And their attorneys referred them to mediation, and they came in and they felt like, this is kind of an annoying process. We have to sit here and talk to each other. So they kept having court dates, and they would go to court and they would think, we're going to see the judge now. And they would meet with the clerk, or they would get an adjournment. The clerk would say, what's going on? And the attorneys would say, well, they are working mediation. And they'd say, okay, let's adjourn for 3 months, come back in 3 months. So they ended up over about 14 months, they ended up settling everything in mediation because they kept coming back. But, they kept reaching an impasse and saying, oh, well, we're going to the judge in 2 weeks. I'm sure we'll get an answer on this. And in that 14 months, they never got any rulings from the court.
And that can happen, and it can be frustrating. Sometimes judges can push you towards a direction in which could be helpful. If people are really stuck in a position and the court is interested in sort of helping break that impasse, sometimes they could foreshadow where they may go or actually make a decision on an issue. So, there are ways in which the court can sort of break that tie or break that loose a little bit, and sometimes it then helps settle. But, being in a room together is always helpful. And that's why even in court, a lot of deals are made in the hallways because the judge says, go figure this out, which is sort of a collaborative type of thing, a mediation type of thing where it's just I mean, granted, sometimes it's attorneys shuttling back and forth between their clients and saying they'll go to 6 out of 14 nights. Well, I want 7. Well, how about 6 and a dinner? And then you're going back and forth. And ultimately, this shuttle diplomacy isn't so different from the idea of mediation in that you're in the same place, you're in the courthouse versus in a room in an attorney's office or on Zoom or whatever the case may be. But it's the act of being together and having to sort of move it forward, which usually leads to things being settled more so than through motion practice or through trials.
Yeah, so that's really interesting. The two attorneys and the spouses are standing in the hall together, and you're ending up basically negotiating the way that you would in a collaborative process.
Right.
But you're doing it with the court, right there, ready to take it from you, and I guess also giving you little nudges in one direction or another so that you have some insight into perhaps how the judge might rule.
Right, and it's, we're stuck on this issue, Judge. We're stuck on whether this dinner is going to be 2 nights or 2 hours or 3 hours.
Right.
And sometimes the judge will say, well, then go figure it out. And, usually meeting in the middle is a good way to go. And that nudge can help.
It seems like subway delays could make the difference between a dinner being 2 hours or 3 hours.
And to think how much money people can spend on that and how much emotion they can put towards that would be better put elsewhere, to their jobs, their kids.
It must symbolize, contact with their child and, the pain of like not having your kid around for half the time, especially before they're 12 or 13. It's painful. After they're teenagers, it's better.
I mean, look, it's rooted in good. People are not, I don't think clients are inherently bad for the most part, right? They're trying, in their mind, there's a valid reason for why they are trying to push on a particular issue or trying to get that extra night or that extra hour, whatever the case may be. For us as the lawyers, it's much easier, and I think part of our job, to take the emotion out of it and say, look, are you going to spend $50,000 on 1 hour of time with your kid? And sometimes it's yes, every hour to me matters, but at least to a degree, it's all right, well, then that that's the decision that you're making, recognizing that maybe, to your point, in 10 years, is your son or daughter really going to know that 1 hour is, was fought over? And are they going to be more resentful that they were put through this whole process over that hour than if you didn't have that extra hour?
Right, because kids always know what's going on with their parents' divorce. And I think that they live with it as a puzzle, that they keep like putting pieces together. And, they turn 16, 17. They remember something that happened when they were 4 or 5, and they go, oh, that's what was going on. I mean, I had a good friend who in her 20s, she suddenly remembered that this 2nd grade teacher in her school would come over and talk to her during recess, and it wasn't her teacher. And her father had multiple affairs. And she went to her mother, and because her father had passed away. And she said, did Dad have an affair with a teacher in the school? And her mother confirmed it. She said, yes, it was this 2nd grade teacher. So, it was 20 years later that my friend realized it. But she was carrying these little mysteries around in her head and always trying to figure out what was the truth of what happened.
Yeah, it's interesting. Kids are very smart and they're very perceptive. And as much as you think you're hiding it from them, you're probably not. And sometimes the smarter the kids are, the more they're able to weave themselves into the situation. And unfortunately, I've had that in a few instances in which the children are able to play or manipulate both of the parents. And it creates, or even just one of the parent or is doing things that they know, especially with access to the internet and things like that. Like, kids can look things up very easily and figure out how things may work in the court system and what may be going on as kids get a little bit older.
Wow.
And weave themselves into that and really play an active role, which is a challenge. It makes things even more challenging. Or when they're appointed an attorney, they use that attorney as their mouthpiece to try and get what they want and kind of almost weaponize sometimes the attorney and their role in the process. And that makes for even greater challenges too.
Wow, that's so interesting. So what have you seen kids be able to do? And like what age kids?
I mean, I've found a lot of times when you have the middle school kids, they're the ones they're in a transition age anyway, and now add this big life event in it too. And, tell their attorney, I only want to be with mom or I only want to be with dad. And then, the attorney has a decision to make whether they're substituting their own judgment for the child, which is kind of a high standard, or if they're going to set forth what the child's wishes are before the court. And now
And the attorney for the child is deciding which to say to the judge?
Yeah, so their role is usually almost always to express the child's position. If, there are instances in which they're allowed to substitute their own judgment for the child's wishes. But I think that a lot of times it's a high standard to be able to do that. It's about safety and things like that. And so now you have a child who says, hold on, I have an attorney. My attorney's going to tell the court what I want. And now, that carries a lot of weight, because when the attorney for the child is saying, the child is saying they don't want to spend any overnights with mom or any overnights with dad, the court's going to listen to that for better or for worse, and it's going to impact the process.
And isn't the child going to have guilt forevermore because the child told the attorney, I want to spend more time with mom, and then dad breaks down crying? And
I mean, I can't imagine it's great for the relationship between the child and both of their parents, but especially the one that they're, I don't want to say going against, but the one that they're going against.
They're not picking.
Right.
But to ask a child to pick one of their parents, shouldn't children be, I think children need to be allowed to love both parents.
And ideally that's the response is to their attorney. I love both of my parents.
Yes.
I'm comfortable with both of them. I'd love to spend time with both of them. But the concern sometimes is that they've now realized the power that they have, and the children and can use that power. I find the high school kids are more like, I'm going to sort of do what I want. And to your point, when they're teenagers, it's hard to how do you tell? Technically, custody is still 18, but how do you tell a 16-year-old that they have to go to a certain parent's place at a certain time?
Yeah, and then these days, at least in New York City in high school, they're going all over the city. They have friends in, from the Queens to the Bronx to Staten Island even. Yeah, so it's probably hard, with 16-year-olds to get them to do what the parents want.
Right, their response will be, I'm just going to hang out with my friends and I'm going to choose them over both of you.
Right, and I'll stay at the home of the parent who lives closest to the friend I want to see that day.
Exactly.
Wow, that's so interesting, though, how children can actually steer the process to go in different directions. I have a very difficult case right now that's in a collaborative process where the father has a history of alcoholism, and he's sober now. But he wasn't for many years, and he disappointed that he wasn't really present, and he was paying child support all along, but just not present in the children's lives, and things were planned, and he would not show up because of his disease of alcoholism. And the mother almost has PTSD. She really suffered and struggled. She's just been fighting and working so hard to take care of these kids alone. She just can't stop thinking about how wronged she's been. So it's a very tough case because she has saved up a lot, and her pension is bigger because the father was in and out of work. And she feels like, now you're punishing me and telling me that I owe him money. And I don't think I owe him anything. I'm glad he's sober now, but I don't see that I should pay him anything. And of course, his attorney is just looking at matrimonial law, which would divide anything saved and earned during the marriage as 50-50. And I feel like they're on the cusp of leaving the collaborative process and going to litigation. And it seems to me that there are arguments on both sides. I have no idea what a judge would do. I have a feeling that it would depend on who the judge likes more, or I guess finds more credible is the legal way of saying that.
And those, unfortunately, are a lot of the cases that end up in litigation where there's really good arguments on both sides. And you need someone to weigh in, because unless you can really break that impasse, which ideally can be done in the mediation or the collaborative process, but if you can't break that impasse, now you need someone in a robe to break that impasse, because both the stronger the arguments that can be made on each side, the more people tend to dig in, which from an intellectual standpoint, as an attorney, is interesting. I find it fascinating to make these types of arguments, to see the arguments that the other side sets forth, to present those in front of the court, to see how the other side presents it, and to ultimately see where the courts fall. But a lot of times the courts don't want to be making these types of decisions. I think in the financial arena, They tend to be more willing to rule one way or the other, because while money is important, it's a lot less important than your children. And so in the custody arena, you'll see, why don't you conference with my court clerk or my court attorney, and we can see if we can figure this out? Or why don't you go in the hallway and try and figure this out? And if not, I'm going to make you come back after lunch. Mm-hmm. And I think coming back after lunch is always a big threat in the courthouse. But that's why, even if you're in the court process or in the litigation process, the judges still want to settle. They don't want to have to sit at trials, because it slows them down from doing everything else. And I think at the end of the day, they do recognize, most are parents, but they also recognize, like, why should I be the one making the decision about what happens with your children? And sometimes it's just gets to that point where it needs to be done. But ultimately, that's why you said it earlier, a lot of cases don't go to trial, because they get to that point and maybe they settle then. But if there's any indication of, oh, here's a motion that you lost, or here's a motion that the court ruled on this way or that way, it gives you a little bit of an indication of perhaps, like you said, who the court finds more credible, or which argument they find to be stronger. And that could maybe lead you closer to settlement, because you have an idea or an understanding of where the court is heading, and it maybe doesn't make sense to dig your heels in if you're likely not going to prevail.
Right. I really don't know how this would come out, because I don't know whether the court would say, look at all the ways that this guy screwed up, and all the hurts and disappointments that he caused his wife and his children, and the history of alcoholism. And so far he's sober a year, but we all know that alcoholism is a very tough disease to live with, and it takes constant vigilance. And would the court be concerned about that? I mean, certainly in the collaborative process, we can talk about what happens if he falls off the wagon, and have a process for that. But I don't know whether a judge would come up with that kind of thing. I feel like it could go both ways. Like, the court could find this guy, he's now stepping up, and he's now wants to have a relationship with his kids, and he is sober. He's working hard on his sobriety. He's held down a job for a year. He's doing all the right things. And the court might think, you're an inspiration. You're an upstanding guy. And feel like the wife is stuck in the past. But then arguments on her side are all the history. And, she's been like mother and father to these kids, and working a very demanding full-time job at the same time. And, the juggling of the childcare, and who picks up the kids, and who brings them to their after-school activities, and who makes dinner for them. And just, she's had to arrange all of that because she didn't have another parent assisting her. And single parents, work twice as hard as double parents do. And the court could see her as very, very sympathetic.
You don't know how the judge is feeling on that particular day,
Right.
How they're going to interpret the facts. And it's, to a degree, there's some crapshoot element to it. But what you said that really resonates with me is that when you're in the collaborative or the mediation process, you're able to talk about what happens if he were to say falls off the wagon. And I always find it interesting when we're drafting agreements, separation agreements, or stipulations of settlement, settling divorce cases that come out of mediation or come out of collaborative versus come out of either the litigation process or more of an attorney to attorney negotiation, which is a fair amount of the way that cases are handled too, because I find it much more challenging to draft the agreements from collaborative or from mediation, because people have the opportunity to be so clever in what they've done and create something that works for them. And it's not boilerplate, and it's something where, okay, when you're talking about it, it sounds great. And then now you have to put the pen to paper, or the keys to the Microsoft Word, and you're in a place in which you're like, okay, well, now what if this happens? And what if that happens? And now we've just, some of these things that sound great are great. And now you just have to figure out how to word them and workshop them. But to me, that's a great problem to have, because it means you came up with really creative solutions.
Well, I guess it's almost like you have to take off or move to the side your lawyer hat when you're doing these things, because some of them are aspirational. I mean, there's the, Child's Bill of Rights, which I love as a document. I put it in every agreement that I draft. And it says things like, don't put your children in the middle. Don't ask them to choose between you. Don't ask them to take messages between you. And your children have the right to love new partners that come into their parents' lives. And I've had people who look at it and they print it out and they stick it on their refrigerator and say to the kids, these are your rights. And if we start to violate this and you feel torn in half, you come and tell me that I made a mistake, which I find like really a moving thing. But then I've also had clients and reviewing attorneys look at my agreements and say, promising that you're not going to ask the child to take a message to the other parent. And what if he does? This is unenforceable. This is ridiculous. So, I sometimes put things in the agreement and people ask me, what's the remedy if they violate it? And I have to say, there is no remedy. I mean, what are you going to charge them $50 for breaking? This is, in some ways, it's aspirational. In some ways, it's here to remind you how your child is feeling. That's really the purpose of it.
And I think it's important, and I include it in my agreements as well, because I agree with you, even if there's no teeth to it, and you can't go to court and say, like, they did this, which, sometimes that is when there are modifications for custody, those types of, essentially they boil down usually to violations of the Children's Bill of Rights when you really think about it. But at least there's an agreement that you can both look back at and say, this is what we agreed to do, which is exactly what you were saying. And we have a phrase that you'll hear if you walk the halls of our office all the time, which is there's no parenting police, right? So if you choose to do something different and you're able to agree on it, fantastic. Right. But if, at the end of the day, someone's not knocking on your door saying, well, actually, you're not allowed to change this Saturday for the next Saturday because your agreement says otherwise. And sort of the thought behind that is the agreement should be a fallback. In the event that the two of you can't figure something out and you're stuck, go to the agreement because that's what you live by. But ideally, that thing's in a drawer and you're not seeing it because you're able to work it out together and make modifications that work for you as a family, because while you may no longer be married or you may no longer be together, you will always be inextricably tied by your children. And so you need to be able, or ideally be flexible with each other to make it work, because that's what's in the best interest of your kids, which is the phrase that we hear all the time. But when you break it down, that's what your goal is as parents, to do what's in the best interest of your children.
Ian, it's been a pleasure talking to you. I feel like we could talk for another podcast. Maybe we'll do a part 2. It's just interesting to me to hear, your perspective as an attorney that does all 3 processes, as opposed to my perspective, because I never did litigate. Do you have any particular takeaways that you would want our listeners to remember?
Yeah, no, I think it's sort of in the name of the podcast, right? And
keep the kids in mind.
Keep the kids in mind. And when you come from that angle, I would hope it helps everything else fall in place. Whether it's financial, keep the kids in mind. Do you want to spend all of this money that could go to your children instead? Do you want to fight over this, whatever it is, when you could put that money to your children? Keep your kids in mind when you're deciding what your parenting time is. Does it really matter that you're going to have that extra hour or two? Or will your kids be happier that you and your co-parent can figure it out together, more so than fighting over those few hours or that one overnight or whatever the case may be? And so I think that the title is perfect, because that's something that I try and make sure to tell my clients all the time, whether it's mediating, collaborative, or litigating. It's just whenever parents are separating, make sure the kids are first and keep them in mind.
Yeah, I agree 100%. I guess that's the name of the podcast. Well, thank you so much for coming on.
Thank you so much for having me.
It's been a pleasure talking to you this morning.
Thank you, Rachel.